point I'm told everybody's lined up. You can bring in the jury, please. You may be seated.
Just maybe approach very briefly.
Yes. All right, if you could please stand, raise your right hand, and be ready to be sworn.
Do you solemnly swear or affirm that you will well and truly try this issue between the state of Florida and the defendant and render a true verdict according to the law and the evidence, so help you God?
Yes.
Thank you.
You may be seated. Ladies and gentlemen of the jury, at this point you've been selected and sworn as the jury to try the case of the state of Florida versus Grant Amato. This is a criminal case. Grant Amato is charged with first-degree premeditated murder. The definition of first-degree premeditated murder will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Grant Amato, in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statement, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been submitted, the attorneys will have an opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law that is applicable to this case. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of this case until you have heard all of the evidence, the arguments of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including fellow jurors, about this case. No communication includes emailing, text messaging, tweeting, blogging, or any other form of communications. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify the court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you in your presence about the case. If anyone attempts to say anything to you or in your presence, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to my court deputy, who will then advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or computer or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and myself, the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any means at all to get information related to the case or the people and places involved in the case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask a question about the trial. In the age of electronic communications, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about the case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I, as the trial judge, have no way to make sure that the information you obtain is proper for this case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, the defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of the defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained, in other words, upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such conferences may be required or how long they will last. When such a conference occurs, they will be conducted so as to consume as little of your time as it is necessary for a fair and orderly trial. Now, if you wish, you may take notes during the trial. You may, if you would like to, you may do so. On the other hand, of course, you're not required to take notes if you don't want to. That's left up to you individually. You've been provided with a notepad and a pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During the recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you've completed your deliberations, the court deputy will deliver your notes to me, and they will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceeding. Your notes should be used only as aids to your memory. Whether or not take notes, you should rely on your memory of the evidence and not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During the trial, you will be permitted to ask questions of witnesses in case you missed something, you did not understand something, or you need to clarify something. The rules of evidence apply regardless of whether a question is asked by the attorneys, by me, or by you. Therefore, there may be a legal reason why I will not ask your question. If I do not ask your question, you must not hold that against any of the parties. You must not discuss it with the other jurors. And please do not take it personally. Subject to that understanding, this is how we will proceed. When the attorneys have finished asking their questions, I will ask whether you have any questions. You may raise your hand to get my attention. I will give you time to write your question or questions on a clean piece of paper, and I ask that you please use a whole sheet and not tear it, and give the paper to the court deputy. I will then confer privately with the attorneys. If I ask your question, the witness will then answer, and then the attorneys may have follow-up if they choose. The questioning of a witness is a primary responsibility of the attorneys. If your question is not asked, you must not discuss it with the other jurors or hold it against either party. You are not obligated to ask any questions, but if it will help your understanding in the case, you may do so. Now, at this time, the attorneys will have the opportunity, again, to make opening statements. As I stated, an opening statement is what they believe the evidence will show. It is not evidence, and you are not to consider it as such.